Some cases aren't criminal, but they can still turn someone's life upside down. I'm talking about cases that might determine parental rights, decide who gets guardianship, or figure out whether someone has the mental capacity to sign a will. If most civil cases only need preponderance of the evidence, what happens when the stakes are higher, but nobody's facing jail time? That's when courts use a tougher standard called clear and convincing evidence. Clear and convincing evidence means the judge or jury has to walk away with a firm belief, a strong conviction that the claim is true. It's more demanding than clear and convincing evidence. Here's the breakdown. Preponderance of the evidence means about 51% sure. Beyond a reasonable doubt is about 95% sure. Clear and convincing lands in the middle, roughly 75% certainty. It's confident, but not absolute. This standard kicks in when the case affects major personal rights: parenting, autonomy, mental health, or accusations of fraud. The court wants stronger proof. It's not, do we sort of believe this is true? It's, are we clearly convinced? Think of it like a pyramid. The bottom is preponderance of the evidence, used for everyday civil disputes. In the middle, that's clear and convincing evidence, meaning it takes real effort to get there. And at the top is beyond a reasonable doubt, the highest standard of proof that is reserved for criminal cases. As the consequences get more serious, the higher you climb. Let's look at an example. The state wants to terminate someone's parental rights. While nobody is going to jail, the outcome could permanently separate a parent from their child. Because the stakes are high, Florida requires clear and convincing evidence. The state has to bring solid proof, witnesses, reports, documentation showing the parent is unfit. If the judge has serious hesitation, then they must say the burden of proof is not met. Another common example is with guardianship cases. Imagine an older adult showing signs of dementia, and the family asks the court for guardianship. Before the court takes away someone's right to make their own decisions, they need clear and convincing evidence that the person truly can't safely care for themselves. That might include medical records, doctor testimony, and statements from people who know them. If the judge feels clearly convinced, not 100% certain, then the standard is met. Clear and convincing evidence is designed to protect everyone involved. It stops people from losing major rights on flimsy claims. And it also lets the court act when the evidence is solid, even if it's not perfect. It's a balance. Not too easy, but not impossible. People think clear and convincing means more evidence. But it's not about quantity. It's about quality. About how strong and believable the evidence is. You could have stacks of weak documents and still lose. Or one credible witness and one solid piece of proof could win a case. Quality matters more than quantity. Here's the quick rundown. Preponderance of the evidence means more likely than not. Clear and convincing evidence means it's highly probable. This burden is used when rights or reputations are on the line. Beyond a reasonable doubt is the highest standard reserved for criminal court cases. In Florida, clear and convincing evidence shows up a lot in guardianship and mental health hearings, termination of parental rights, fraud and misrepresentation cases, certain property or probate disputes. It's the safeguard courts use when someone might lose autonomy, parenting rights, or their reputation. Now you've seen where clear and convincing fits between preponderance of the evidence and beyond a reasonable doubt. Here's the next big question. How can the same event have one outcome in civil court and a totally different outcome in criminal court? That's what we're breaking down next.